Good evening, this is John Milburn for Laws 13010, Evidence and Proof. We're into week 6, and the work for tonight is to do with documentary and real evidence, and the text is chapter 10 of Field. I'm getting a sign coming up that my internet connection is unstable, so if I drop out, please excuse me. My little laptop is working overtime. The reason I'm running late is that I was conducting trusts, and we seem to be always running late with trusts. There's a lot to cover. Anyway, evidence and proof. The first assessment, thank you very much those of you who contributed and participated in that exercise. I hope you enjoyed the exercise. It's a little taste of what you might expect in practice. It's actually quite realistic in many ways. And as we discussed early in the course, if you're a prosecutor, your job is to lead the evidence. If you're the defence counsel, your job is to attack the evidence. Very substantial difference, of course, both in terms of the outlook, the approach that you adopt, and also the technique that you adopt. So in terms of marking the exercise, there is a rubric, and I was looking for certain things, the questions to establish the relevant facts, questions based on the witness's own senses, demonstrated the role of the parties in giving evidence, being able to deliver questions in a clear manner and build on the questions and some higher order issues. So as a prosecutor, your role is to ask questions which are designed to extract, and I use that word guardedly, from the witness the evidence, but to do so in a way that the evidence is still the witness's evidence, it's on target, and you're controlling the process. So it was a matter of asking targeted questions to elicit a response from the witness in relation to an issue that was of interest to you at that moment, and then move on and control the process. Some students asked very broad questions, which is fine, but you may get a very broad response. So as a prosecutor, for example, you may say, and what did you see? It's a perfectly acceptable question. What you want is for the witness to say, I saw a white delivery van arrive at the scene. What you might have got is, I saw a lot of people in the park having barbecues and a few people were swimming. That's not what I want. That's not what I want. So it's a matter of, as a prosecutor, and I reckon being a prosecutor is harder than being defence, trying to ask the right question to extract the appropriate answer. Another thing is that some students got into a habit of saying, and what happened next, and what happened next, and then I took them off on a different tangent because you weren't directing me in a certain way. And it's a really difficult thing to do. Of course, in amongst that, the traps in the exercise were, I didn't want you to ask a question that had the result of leading me to say something which is inadmissible. You didn't want to ask a question that had the result of me then saying something which is opinion evidence or something which is hearsay evidence. So there are a lot of traps in that statement for people to get me to say something that was clearly inadmissible. From defence perspective, what you're really looking to do is ask questions which are absolutely leading questions and putting a proposition and getting a yes/no answer. And just hitting the witness, not necessarily quickly, but in succession with a series of propositions, yes, no, yes, no. Do you agree with this? Yes. Do you agree with that? No. Blah, 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 until you get to a point where the picture is painted by the witness again, but in such a way as to make it clear that there's got to be some doubt about this. So did you see the content of, did you see what was in the duffel bag? No, etc. Things like that. So you're sort of building the case in reverse, but you're making sure that the witness did not have a chance to elaborate on the story. So one of the common mistakes in defence counsel was to ask open-ended questions And that gave me, as the witness, an opportunity to add some things in that really didn't help the case. So the prosecutor may have left certain things alone. It would have been in the best interest of defence to leave those things alone. And where defence came unstuck on some occasions was asking the wrong question, which gave me a chance to bolster the prosecution case by the evidence that I gave, or to ask one too many questions. You know, you had the answer, you had what you needed, ask one more question, and then bang, you think, oh. So, for example, some people may have said in defence, do you need prescription glasses? No, sorry. Do you need prescription glasses in order to see? No. So your eyesight is good then. Oh no, my eyesight's terrible, for example. Oh, why do you say that? Well, I always wear contact lenses. So you can see, and that might have been a prosecutor trying to establish that I could see clearly. They've asked one question. That's a bad example because it was clearly a leading question. But I think you get the idea of asking one question too many sometimes can ruin the situation for you. So in asking the question, sometimes you've got to leave it alone at that. Anyway, they're just a few of the thoughts in relation to the first assessment. Do you have any questions arising from what I've been saying? It's okay to ask questions. Did you want to ask a question, Kate, or are you just not muted?
No, I'm good. No,
all good. Okay.
I sort of knew what to expect out of the assignment too, so.
Okay, all right. So documentary and real evidence, tonight's topic, chapter 10 of Field. I hope that you're finding Field a very good textbook. I think it's great. I think it's really well done. So what do we mean by real evidence? What's real evidence mean?
Things.
Things, yes. Good answer, Catherine. Yep, things. Yep. An object, for example. A knife is always a good example. Something that's produced in evidence to assist in proving a fact and issue. But real evidence on its own is not good enough. What do we need to have to accompany real evidence for it to make sense?
An explanation, an oral explanation.
Yes. Yeah, and it needs to be tendered in some way through a witness, doesn't it? So unless there are certain rules about admission of documents, etc., but generally speaking, a witness needs to explain the situation, put it in context, and the real evidence is then tendered through that witness. What's a document? So that's what real evidence is, and I won't talk much about real evidence. That's about it for tonight. The rest of it will be about documentary evidence. So what's a document?
A certificate.
Yes, that's an example.
For example, blood analysis certificate or a drink drive.
Yep, that's a good example of a document. Where do we find the definition of a document? Where would we look? Those of you who've done trust with me will know what I'm getting at here. Yes, Catherine?
Is it in the dictionary to the Evidence Act?
Absolutely, yes. So we always go to the Act, and in the Act, there'll often be a dictionary. And that dictionary will normally be a schedule. In this case, Schedule 3 to the Queensland Act has the definition of document. And when you look at that, you'll see it's really widely defined. It's not just something in writing, which is what we normally think of when we think of a document. It can be something in writing, for sure. It can be a certificate, as Kate said. It can be a book or a map or a plan or a photograph or a label. Now, it can even be beyond that. It can be it'll be something digital. So it can be data, a film, really anything that records information. It's really broadly defined. So the rules that we talk about in terms of documentary evidence and documentary hearsay apply equally for all of those sorts of documents. Now, I've mentioned that magic word hearsay. We'll see that a lot in the next few weeks. What do we mean by hearsay evidence? Why didn't I want hearsay evidence in exercise 1?
Because it's not direct evidence.
Yes, exactly. It's not direct evidence. So how can we define hearsay evidence?
Something that's not seen or felt or smelt with the five senses.
Exactly. That's a really good way of approaching it. It's something which is, I don't know, it's some sort of out-of-court statement or observation, but something out of court which expressly or impliedly asserts something as true, but it's based on information from a third party, for example. So the classic example of hearsay, and you can see it coming, is, and then I heard something from someone else. Don't ask this question, what did that person say? Only in a few instances will that be admissible. As soon as you start to say what somebody else said, there'll be objection, that's hearsay. So hearsay is referred to in both the Commonwealth Act and the Queensland Act. What act am I talking about in both instances? It's got the same name.
The Evidence Act.
Evidence Act, very good. And the Commonwealth is what we call the Uniform Evidence Act. Okay, so the Evidence Act has the material in both. Let's look at the Queensland statute. Section 92 through to 95 is really important. So they're the main provisions that deal with documentary hearsay, or documentary evidence rather, and they provide the circumstances where hearsay evidence may be admitted. So the value of documentary evidence, and Kate, you alluded to it earlier, is that if you've got a certificate, it's something that tells the court about a circumstance. It's hearsay because it's in a document, and documentary evidence is inherently hearsay evidence because you need someone there to say, this is what I wrote, here's the support for it. In itself, a document is hearsay evidence, but it's admissible in many circumstances. So have a look at sections 92 through to 95A. And what's really important is, firstly, the distinction between the admission of documentary evidence in civil cases as opposed to criminal cases. So there is a difference in terms of the admission of documentary evidence in those circumstances. Now, I've given you a bit of a hint in terms of identifying sections, but can you tell me where you would need to look to consider the law in Queensland, in the Queensland legislation, regarding the admissibility of documentary evidence in civil cases? Where would you look?
Section 92.
92. Very good, Catherine. Thank you. So 92. So if you haven't already got your Evidence Act up on the screen, would be a good time to get that there, or have it in paper version. So I've got actual paper version which I bought from the printers. So section 92 deals only with civil cases, and it basically provides that certain documentary evidence which would be otherwise inadmissible as hearsay is admissible in certain circumstances, and it lists those circumstances. So basically you'll see there that the maker of the statement had personal knowledge and is called as a witness. That's what we were talking about before with the knife. I think Diana said it. Or the document forms part of a record for some sort of undertaking. It's funny that the Parliament used the word undertaking. It's very broad. What do we mean by an undertaking? Used as a noun, not a verb. Or an adverb. A noun anyway. So what do we mean by undertaking? Any thoughts? All right, so undertake. What was that, sorry, Catherine?
So it would be a person who says that will do something or provide something.
That's the other meaning for undertaking. That's a really important meaning for undertaking. But the meaning that the legislation refers to in this context is more the noun, meaning like an undertaking is a business or an occupation or a pursuit. It's an organisation. It's something where there are business records or some sort of record kept by that group, that undertaking, that business, that organisation, and it's really widely defined. But if there's a business record, which is a document, if there's a document which is part of the record relating to that undertaking, and it's made in the course of that undertaking by someone who had or reasonably might be supposed to have personal knowledge of the matters contained within it, then that document can be admitted into evidence, even though technically it's hearsay. And there are some conditions there in subsection 2. So the condition in subsection 1 is that the maker of the statement is called as a witness, but if not, it can be satisfied if that person is dead. So they don't have to be called as a witness if they're dead, obviously, or the person is out of the state. Now, I find that really old-fashioned. What they're saying is that it's permissible to admit a document which is inherently hearsay without the maker of the document being called into the witness box if they're excused, and they're excused amongst other things if they're out of the state. Well, you know, with electronics, it's so easy. It should be so easy to call that person and give their evidence electronically in some manner. Likewise, a document can be admitted into evidence in civil cases. Remember, we're talking about civil, it's in section 92, in circumstances where the maker or supplier of the statement can't be found after reasonable diligence. Or it can be reasonably supposed that the person who made the statement or made the document won't have any recollection of the matters. And also, there are a couple of other exceptions which apply in the civil sphere that don't apply in the criminal sphere. One of those is you don't have to call the person who made the document in a civil case if nobody wants to cross-examine the person who made that statement or made the document. That applies in civil cases. Or they can be excused from giving evidence to present the document into court if the court says that by insisting upon that it would cause undue delay or be undue expense. So that's an exception. Okay, so what we're saying is in civil cases, documentary evidence is admissible if you call the person who made it or had reasonable, or you reasonably supposed had knowledge about the document in the undertaking, but you don't have to call them in those circumstances. They're out of the state, they can't be found, they wouldn't recall independently what's in it anyway. Nobody wants to cross-examine them, or it just wouldn't be appropriate to have to go to the trouble and expense of calling them. Now, does that make sense? So that's the position for civil cases and the admissibility of documents in those circumstances, section 92. All good? All right. So section 92 permits, if you like, the admission into evidence into civil cases of two types of hearsay document. The first is what we call hearsay, first-hand hearsay. So it's a document which contains a statement by the maker who had personal knowledge of their contents. It's hearsay, but it's only once removed. It's only one level of hearsay. The second is that it can be, second category of hearsay, that is, it can be supplied by a person who had personal knowledge in the course of the undertaking. So it can actually go to a second level. And it can be that both. It can be that the person who made the document actually had some knowledge of it, or it might be material that was produced in the course of the undertaking. So it can be both. All right, so have a look at section 92 and get an idea of what we mean by undertaking. Now, we've already answered this before in the context of another question, but where would we look to find out what is an undertaking? I suspect Catherine will be right onto this answer. You can beat her to it. She's holding back so that somebody else can answer it, I can tell. Where would you look to find out the definition of undertaking in the Queensland Evidence Act?
In the dictionary.
Thank you,
To the
Catherine.
Evidence Act.
Thank you, Catherine, with a C. Absolutely. All right, so it's very wide, and it talks about a business or profession or an occupational calling or trade or undertaking, whether it's the Crown or for profit or not, or Queensland or elsewhere. I find that definition unnerving because the word that they're trying to describe contains the word itself. I never liked that as a drafting technique. But anyway, have a look at undertaking and in the dictionary. And remember, of course, it's not for a criminal proceeding. And when we're talking about the difference between civil and crime, it can be uncomfortably close. There's a case, I think it's in the notes. Have a look at Chief Executive Officer of Customs against Labrador Liquor Wholesale. It's 2003 216 CLR at 161. In that case, the court said that Section 92 does apply. In other words, it is a civil case where there was a custom officer who sought a criminal penalty against a company for evading payment of import duties on tobacco. Uncomfortably close between civil and criminal. Anyway, the court held that it was civil. 92 did apply in those circumstances. And I should actually correct myself there. The court didn't say it's civil. What they said is it's not criminal. So you can assume from that, but it's not necessarily the same, perhaps. Okay, so we've been talking about Section 92, the admissibility of documentary evidence in relation to civil matters. Where do we find out about the admissibility of documents in the Queensland legislation for criminal matters?
93.
93, thank you. So it's only for criminal cases, so it's one or either. You've got to work out which one it is. And they're very similar, but one thing that stands out to me is that we don't use the word undertaking anymore. Now we use the word business, so it's more confined in terms of the source of the business record. So you know when I was talking about undertaking, it's a really broad range of things that might contain records. It's not just business records, it's records for all of these things that are undertakings. They can all be admitted much more readily into evidence because Section 92 is much broader than 93. But in criminal matters, the court says, no, we're talking crime here, so people's liberty is at stake. We're going to make it, well, Parliament says, we're going to confine the limits on documentary evidence to only refer to businesses, not undertakings. Business is part of undertaking, but it's a subset. So 93 only applies to business. And the other thing is that you're going to have to get people into the witness box to provide the oral evidence that is needed to justify the admission of the document into evidence far more often in a criminal case than a civil case. Now, why do I say that? I'll give you a hint. In 92, there is one of the exceptions, and the exception was that if no one wants to cross-examine, then you don't have to call someone to put the document into evidence. But in a criminal case, that exception doesn't apply. So it's going to be the case much more often in criminal cases that someone will need to come along to court and go into the witness box in order to effectively put into evidence the documentary evidence that you want into evidence in that case. Okay, so have a look at the differences between 92 and 93. And you'll see that there are no equivalents of subsection 92.3 or 92.4. In those circumstances. All right. There are issues to do with 93A. And you'll hear this a lot around the criminal court proceedings. 93A deals with out-of-court statements of children and witnesses with impairment. And 93A works in conjunction with Section 21A. So if you're looking at the Evidence Act, Queensland, have a look at 93A and 21A. And very often you'll hear 21AK is an even more particular section which relates to evidence of children. So 93A in criminal trials deals with circumstances where a person is giving evidence, but they are protected in the sense that they're treated in a special way. And it relates to children and people with impairment of the mind. Children are defined, a person who was under 16 when the statement was made, or between 16 and 17 when the statement was made, who at the time was a special witness. So the application of 93A in criminal trials relates primarily to victims. That's where it mostly occurs in terms of sexual assault. And it's part of that package with 21A. What it means in real terms is that people give their evidence by closed circuit TV, and there are special screens or in the courtroom. And let's have a look at Section 21A. So if you've got that up on your screen, I'd recommend you go and have a look at that now. And the way that I like to look at legislation is I like to look at the headings and the index first to get a feel for the breadth of the sections. And you'll actually see that 21 is quite extensive. And it's all part of Division 4. It's 4, 4A and 4B. And it covers actually just 21 and those divisions cover a huge section of the Act. So it's all about the way in which special witnesses and affected children give their evidence. And Division 4 deals with special witnesses, and that's where 21A is. 4A deals with affected children. 4B deals with recordings, and pay particular attention to 21A, 21AD, which is the meaning of a child, 21AF, 21AG, which deals with the rules about examination in chief and cross-examination, 21AK, I've mentioned that before, that's the video recording of affected child witness, and also look at 21AU, excluding the public, so it's closed court proceedings, and 21AZC, which is publication of recorded material prohibited. So if you look at, we called it a suite of provisions which are designed to protect people that are vulnerable in the context of giving evidence. And the way it works in practice mostly is we look at 93A and 21AK. 21AK deals with the pre-record, as we call it. The pre-record is where the affected child victim will give evidence to the court, but in a very special manner. We call it a pre-record because it's a recording of the evidence of that witness that occurs before the trial proper. It's part of the trial, but it's before the jury is impanelled. So what happens in real terms is this. On a day, the court will list the matter for a 21AK hearing. We call it a pre-record. That's what you'll often hear people talk about, a 21AK or a pre-record. So the pre-record is where the court is convened. It's the start of the trial, but there's no jury. I mentioned about exclusion of the public, 21AU. 21AU applies, so the public are excluded. The closed court sign goes up, and the bailiff will say, we'll give a proclamation, unless you're involved in this case, you've got to leave the courtroom now. So the court, the trial starts. the barristers announce their appearances, an indictment's been presented, the defendant arraigned, etc., and the witness is called. The witness won't be in the courtroom. The witness will be somewhere else. Probably shouldn't tell you where they'll be, but they're not in the courtroom. And there'll be a video link into the courtroom. The child will typically be with a support person in some other location. And the judge will talk to the child, will verify who's in the room, all those sorts of things. And then the prosecutor will start asking questions in examination in chief. So much the same procedure then as if the child was giving evidence in the courtroom in front of a jury. It's just that these special protections apply. Once the examination in chief is completed, then the defence counsel will cross-examine the child in the usual manner, but with some special rules. And that's where I want you to have a look at Section 21AG, which deals with some special rules about the way in which the examination in chief and the cross-examination should occur. So the idea is that the court protects the child in the sense that if the person might suffer emotional trauma or be intimidated or subject to special types of prosecutions involving, say, criminal organisations, then they may either be a protected child witness or they may be a special witness, and you can be really both. But either way, the court will set up a procedure which ensures that they're protected to a substantial degree. Okay, and 93A is a procedure for admitting documentary evidence, and that documentary evidence might be in the form of a statement by the affected child, and that's where it works in with 21AK. So the court says that 93A statements can be admitted. Have a look at Section 21AW, which requires the trial judge to direct the jury that evidence in a statement admitted under Section 93A must not be regarded as carrying any more or less weight simply because it's admitted in that form. So 93A is a special way of getting documentary statements into evidence in relation to children, and it ties in with 21AK and essentially that whole suite. Okay. The other thing too is bear in mind that courts have overriding discretions. So do keep in mind Section 130 of the Evidence Act. It's a handy one in terms of arguing about discretion. So every trial judge has an discretion to exclude evidence if they're satisfied it would be unfair on the accused to admit it. In addition to looking at 93A, do have a look at 93B, which deals with the admissibility of representations in prescribed criminal proceedings if a person is unavailable. So in other words, it deals with hearsay evidence for statements in prescribed proceedings when the maker has died or is mentally or physically incapable. And what it means is that certain out-of-court statements, documents, can be admitted in those prescribed criminal proceedings if the person had knowledge of an asserted fact and made a representation about that fact and is unable to essentially present that evidence. So that's when the hearsay rule doesn't apply to that evidence about the representation, about what the person saw or heard or otherwise perceived through the what's recorded in the 93B statement. All right, but it's not unfettered rule. 93B is a rule that applies to allow for evidence to be presented to the court, which is essentially hearsay, but there are limitations on it. And the main one is that the court needs to be satisfied that it's unlikely the representation is a fabrication. Have a look at the decision of Crump. It's RV Crump 2004 QCA 176. Essentially that case was, Crump was charged with murder of his de facto wife or spouse. The body was found dumped, weighed down in a lagoon in an area of state forest. Now, a witness, K, gave evidence of an occasion where the deceased had called at her home one morning, complaining that C had beaten her the night before, C being Crump. And the Court of Appeal held the statement should not have been admitted because, although it was made shortly after the event to which it was referred, it was not made in circumstances making it unlikely that it was a fabrication. K could not testify to having seen any bruising on the deceased to back up the story. The point I'm trying to make is this, that a 93B statement is admissible in circumstances where a person is dead or mentally or physically incapable, and they made some sort of representation, but the court will be very guarded about allowing that in, and they'll consider whether it's unlikely the representation is a fabrication, and they'll construe that very widely. Have a look at also Section 93C, which provides a trial judge an obligation to warn the jury that hearsay evidence, even if it's admitted, may be unreliable, and warn the jury to consider and give it such weight as they see fit. All right, now Kate earlier mentioned admission through certificate. Have a look at Section 95, which deals with the admissibility of evidence which relates to documents that are computer generated. That's always a useful piece of legislation. I'll give you an example of where 95 can be relevant. Have a look at the case of, it's a district court case, Carolyn against Cohen, Carolyn against Cohen, 2011, QDC 183. In that case, it was just a simple demerit point suspension case. So someone's driving, their demerit point suspended. The prosecutor introduced computer records from Transport Department, relied on Section 95 in order to prove that that person received correspondence from the department to say that they had been suspended. And the court accepted that evidence into material into evidence. And it's part of the rationale for doing that is this. If someone is charged with being unlicensed, the court will assume that that person will know whether they're licensed or not. So, and it's very difficult for prosecution to prove a negative. So if we didn't have special rules, you can imagine how difficult it would be for prosecution to prove that someone wasn't licensed, because they would theoretically have to check the licensing regimes not only in Queensland but interstate and possibly overseas. So sometimes it's easier just to rely on certificates. Have a look also at Section 94, which deals with the credibility of the maker or supplier of a statement. Section 96, which deals with reasonable inferences from circumstances, and corroboration. Now, what do I mean by corroboration? I better stop talking for a sec. What do we mean by the term corroboration? No takers? You sometimes hear this, whether it's possible to secure a conviction on uncorroborated evidence. No one? Yes, Catherine?
There's something to support it.
Yes, whether there's something to support it. That's it, exactly. So have a look at Section 100 of the Evidence Act in relation to corroboration. It says, for the purpose of any rule or law requiring evidence to be corroborated, a statement rendering admissible as evidence in this part shall not be treated as corroboration given by the maker of the statement. So normally, you don't need corroboration as a prerequisite to a conviction, but sometimes you do, in which case Section 100 will apply in those circumstances. I mentioned before an overriding discretion. A really important one is the Christie Discretion. The Christie Discretion only relates to criminal proceedings. It's actually now embodied in legislation. Have a look at Section 130. And basically it says that nothing in the Act derogates from the power of the court in criminal proceedings to exclude evidence if the court is satisfied it would be unfair to the person charged to admit that evidence. That's the Christie Discretion. So if your defence counsel and all else fails, argue the Christie Discretion as to the reason why it should be excluded. It's much better argument than the vibe of the thing, if you understand what I mean. All right. Any questions? Diana understood what I meant there. Okay. Look, there are similar rules in the statutory scheme for the Commonwealth, and have a look at section 59. It's a really important rule in terms of exclusion of hearsay evidence, but also have a look at the whole suite, section 60 right through to probably about 100 deal with that issue. And one really good place to look is section 59 deals with certain exceptions to the hearsay rule, and then very helpfully gives us clear examples. So here are the examples. D is the defendant in a sexual assault trial. W made a statement to police that X told W that X had seen D leaving a nightclub shortly before the sexual assault is alleged to have occurred. Unless there's an exception to the hearsay rule, evidence of what X told Y cannot be given at the trial. So that's pretty much straightforward hearsay. Another one is P told W that the handbrake on W's car didn't work. Unless an exception to the hearsay rule applies, evidence of that statement cannot be given by P or W or anybody else to prove that the handbrake was defective. Again, dealing with hearsay. And finally, W bought a video cassette recorder, this is a very old example, and wrote down the serial number on a document. Unless an exception to the hearsay rule applies, the document's inadmissible to prove that the VCR later found in possession was the video cassette recorder bought by W. Again, writing down the serial number is a document which is technically hearsay. So have a look at that, try to understand those rules and those exceptions, and the examples which are in the Act are a great place to start. I mentioned before first-hand hearsay. There are restrictions on that. So have a look at section 62 and section 63 and 64. They work on first-hand hearsay, and then it flows on to other sections. So I'd read right through to section 66 in terms of first-hand hearsay. This is the Commonwealth Act, the Uniform Civil Procedure Rules. Okay, and I think I've mentioned this before, but if you want a really good way to get your head around this whole issue of admissibility and try to put some structure to it, have a look at the introduction to the chapter which deals with hearsay evidence in the Commonwealth Act. And you'll see a flow chart. And in that flow chart, it sets out in the various parts from 3.1 through to 3.11 how it works in practice. So if you've got the Evidence Act, have a look at the commencement to part 3, the chapter, before 3.1, so that chapter, and it will give you a really good idea of the admissibility issues. Has everyone been able to see that? If not, have a look in the Commonwealth Evidence Act. All right. You've been very patient with me tonight. Are there any questions? All good? And now that you've finished your first assessment, we can all start watching movies and get ready for the second assessment. Has anyone found the movie yet? Started to look at it?
Yes.
Very good, very good.
I have the movie.
All right, Diana, you've been looking? Excellent, very good. All right, well, that's all for tonight.
Yeah.
Thank you for attending. Unless there are any questions, no, nothing on the chat facility. All right, well, I'll stop the recording now and we'll see you next week. All the best. Bye.